Hello. The last 6 months has resulted in a lot of changes, both to our profession of policing and for the Broomfield Police Department. None more so than the passage of Senate Bill 20-217. This occurred so quickly that we've had to spend quite a bit of time in trying to decipher what was the exact intention of the legislature as it passed this bill. The training video you're about to see shows some of the answers that we have, provides some direction, and hopefully some reassurance to you as you continue to do the great work you do in the city and county of Broomfield. Nothing in the bill prevents police officers in engaging in ethical, legal, moral, and responsible policing. It's intended to stop the unethical, irresponsible, and illegal police activities like we've seen around the country. We realize that this training video is not going to answer all the questions you might have, but I assure you, our legal department, in cooperation with the FOP's legal department and other city and county attorneys throughout the state of Colorado, are working to get answers to many of the questions you may have. This is simply our first step in answering some of the most important questions you will have as a result of the passage of 217. Thank you, and be safe out there.
So my name is Christina Penny-Helm. I'm an assistant city and county attorney in Broomfield. We are going to talk today about the new law that is affecting police officers in Colorado. It is called the Enhanced Law Enforcement Act, and it might be better known by some as Senate Bill 20-217. Today we're going to go over a general overview. There is a lot of stuff in this bill. So we're going to go over a general overview, talk about what the words say and potentially what they mean. As everybody knows, this moved really fast through the legislative process. And so there is inevitably going to be changes to this law. There has to be clarifications. There has to be guidance. Case law will change how we interpret this bill as well. So as that comes down, this is definitely not going to be the first time we're going to talk. We will be providing additional training as needed. And also to let everybody know, there has been a huge collaboration in Colorado among attorney groups, among sheriff groups, police groups. I've reached out to FOP attorneys. We're all working together to try and get the best interpretation of this act that we can and pass that along to officers. So today what we're going to cover is a few key areas in this bill. That's going to include changes to body-worn cameras and the release of video. We're gonna address the changes to the use of force policies and deadly force, the word changes. We're gonna address the new duty that's in this now in Colorado statute, duty to intervene. We'll talk about the consequences of certain areas to officers as they're performing their duties. We'll talk about a new civil liability that has been created with this law. And we'll also talk about a new data collection and anti-profiling provisions that have been added. I wanted to start off with a good news slide. The good news is, as I was reviewing policies and talking with a lot of people here in Broomfield, a lot of the new requirements in this bill are already in Broomfield policy, and officers are already practicing them now. So although it might be new words that are being used, in practice, it's a lot of the same stuff that officers are doing. So the first big category that we're going to talk about today is body-worn cameras. So there's new requirements, new provisions about body-worn cameras and what officers have to do while wearing them. This part of the statute doesn't come into effect until July 1st of 2023. And the reason that happened is some organization, entities, police departments don't have body-worn cameras. So they wanted to provide those entities time to get them, start them, and create policies of how to use them. Broomfield, as everybody knows, already has body-worn cameras. And so it's important to know as we move through this is an area where officers are already doing a lot of the requirements that the law is asking for. So first of all, the new law says that officers must wear and activate body-worn cameras in the following situations: when responding to a call for service, or during an interaction with the public, when that interaction is initiated by the officer, whether that's consensual contact or non-consensual contact, for the purpose of enforcing the law or investigating possible law violations. So that's pretty broad, right? But that's a lot of what you do now. So if you're responding to a call, you get out of your car, you put your body-worn camera on, right? If you're speaking with someone for a law enforcement purpose, generally you put your body-worn camera on. So it's just a continuation of doing what you're doing and making sure that the camera is on. There are times when the body-worn camera can be turned off that include turning it off to avoid recording personal information that's not case-related. So an example of that would be if you're walking into a hospital to go talk to a witness or something. You turn the camera off because it could potentially get medical privileged information. The other time where body-worn cameras can be turned off is when there's a long break in what the officer is doing. So from the time of response, there might be a long break when you're doing paperwork or you're waiting for a tow truck or to tow a car or something. Then during that long break, the camera can be turned off and turned back on when you are being active again with witnesses or the suspect. It can also be turned off during administrative, tactical, and management discussions, which I've seen now. So when you're on scene and you're talking with other officers to determine, what type of charges are you're gonna make, I've seen where the camera is muted. That's still allowed. No body-worn cameras are required if you're working undercover. And for detention officers, a body-worn camera must be used if there's force that's anticipated, if you're doing a cell extraction, or if a restraint chair is going to be used. This next slide talks about consequences for times when the body-worn camera is not activated. So the first point is that in an investigation, and that can be an internal investigation, or a legal proceeding, which could be a court proceeding, if an officer fails to activate their body-worn camera or tampers with the footage, there is now allowed what's called a permissive inference that the missing footage would have reflected misconduct by the officer. So what does that mean? Permissive inference is not used a lot. So what that means is that a final decision maker in an internal review or a judge is permitted to use the inference that the missing video might have included video of officer misconduct. And because it's permissive, they can make that inference, but they don't have to. And there's also consequence in criminal prosecution. So that could be when you're in court and there's a suspect that's been charged and you're in court for that, there's now a rebuttable presumption of inadmissibility of an officer's statement because there's no body-worn camera footage. So what that means is, the court, the decision maker can make a presumption that the officer's statement is not admissible in court. The officer and the prosecutor have the ability to rebut that presumption. However, this is now permissible in these types of cases. This inference and presumption does not apply in certain situations. If there's a malfunction of the body-worn camera, if the officer or the malfunction and the officer was not aware of the malfunction and was unable to fix it, and prior to the incident, documentation shows that the officer checked the functionality of the camera at the beginning of shift. So this is just an important reminder that before you start shift, you check your camera, you make sure it's working, and you document that, because that can definitely be used later, down the road if something happens to video, that can be used to explain what happened. All right, this new law also includes some other consequences. So if there's a finding that an officer intentionally failed to activate their body cam or tampered with the footage, so tampering means intentionally doing something so the footage is no longer there, then the law requires that discipline be imposed. So a finding would be a finding by a court or a hearing officer or a final decision maker in an internal review process. And although it does say that discipline is to be imposed, every officer, just like every employee in Broomfield, is entitled to the protections of the personnel merit system. So that system still applies. However, discipline has to be looked at if there's this intentional conduct by the officer. Also, if there's that finding of intentional conduct, then Post is required to suspend certification for up to, or not less than a year. So that's a year of time where certification would be revoked, unless exonerated by a court. So exonerated by a court isn't defined anywhere. But as you know, there's appeal rights, right? There's appeal rights to internal findings, there's a court appeal rights. So if court at a later date finds that the officer's actions were not intentional, then there's a potential to get the post certification back. If there is a finding of that same intentional conduct of failing to activate the body camera or tampering with footage, and the incident that was not recorded resulted in death of a civilian, then there's the potential for permanent revocation of post certification. The way this is going to happen with Post, we don't know that yet, because Post is required to come up with rules, regulations, and procedures of how that's going to happen. We haven't seen that yet. And so we will definitely keep you updated on what we hear about that. But that there's also potential, if exonerated by a court, that that revocation could be changed. All right. The new law also requires a mandatory release of body cam information. And this is for you to be aware of, not necessarily anything you have to do. But a release of body cam footage is now required in incidents where the police department receives a complaint of misconduct. And so in those instances where there's a complaint of misconduct that the department has received, we're required to release unedited video, except in certain circumstances. We're able to redact personal information, juvenile information, stuff like that. And that release of video has to happen within 21 days after we receive that complaint. There are times that we would be able to hold on to that video a little bit longer if it would interfere or jeopardize with an ongoing investigation, but we would still have to release that video within 45 days after the alleged misconduct. And there are opportunities for criminal defendants, if there's an ongoing active case, for them to petition for the video not to be released. So that's all for the section regarding body-worn cameras. We're going to move on to issues regarding force. So the first topic we're going to talk to about force is this new prohibition in the Act regarding to actions during protests and demonstrations. And so this area of the Act was included purely based on the temporary restraining order that was issued in Denver by a federal judge during the recent protests. So he came down with an order and had specific mandates in it, and those mandates were included in this new law. The first thing is that during protests and demonstrations, officers cannot target certain areas of the body, so cannot target the head, pelvis, back, or shoot indiscriminately with kinetic impact projectiles. And secondly, officers must issue an order to disperse and provide time and space for people to leave before using chemical spray or irritants. All right, so now this 18-1703 has to do with use of force in jails. The wording in this statute has changed a little bit, but the actual practice of detention officers generally doesn't change. So the old standard under this section was that officers were able to justified in using reasonable and appropriate force. That was the old wording used. The new wording used is force is justified in order to maintain order and discipline in the jail. The force used must be objectively reasonable and appropriate, and the officer must reasonably believe that it's necessary to maintain order and discipline within the facility. So the change, right, is from the use of reasonable appropriate wording to the use of objectively reasonable and appropriate force. And objectively reasonable, all officers, are familiar with what that means, right? No reasonable officer would have believed that the force used was reasonable or necessary, It's based on a reasonable standard of what an officer would believe and based on the circumstances that they are facing. The statute also goes on to say that deadly force may only be used if there's an objectively reasonable belief that the inmate poses an immediate threat to the officer or another person. So again, that's the same standard that detention officers are used to. It's just using objective reasonableness rather than reasonable and appropriate. The use of force language in 707 relating to actions of police officers also changed. So this is just a reminder that this section deals with, quote, the justification and exemptions of criminal responsibility. So this is found in the criminal code part of, the Colorado Revised Statute. Words were rewritten, but again, concepts are similar to what officers are already doing. The old title was the use of physical force in making an arrest or preventing escape. The new title is use of force by peace officers, so it's a little bit more broad. This section, just like the jail use of force section, is effective September 1st, and that was to allow entities time to train. There are certain sections of the use of force that we'll talk about this policy that are effective now, and that has to do with the prohibition of chokeholds and the actions of officers using deadly force during felony arrest. Those are effective immediately. So the first thing to note in this new statute is that physical force has been given a definition, and this definition is pretty broad. Physical force is now defined as the application of physical techniques or tactics, chemical agents, or weapons to another person. So basically that means physical force means anytime you go hands-on, it meets that definition. Okay, so looking at the language of the revised statute, the old language was that officers were able to use reasonable and appropriate physical force when the officer reasonably believed it necessary to effect an arrest or prevent escape, or to defend him or herself from imminent use of physical force. So that language has now changed to this new standard. It is now required under this statute that an officer consider nonviolent means when possible before using physical force, so before going hands-on. This statute also requires that physical force only be used when nonviolent means would be ineffective to make an arrest, prevent escape, or defend self or others from imminent threat of serious bodily injury or death. So, looking at those two requirements, it goes back to looking at the circumstances and what the officer is looking at. And when possible, the officer is required to use alternatives before going hands-on when able, right? So, you get on a scene, you use the information you got from dispatch, you use the information you're looking at, and you consider to yourself, before going hands-on, is there an alternative, de-escalation, communication type of thing. The next requirement is that officers are not allowed to use deadly force to arrest a suspect for a minor or nonviolent offense. Minor or nonviolent offense is not defined in this statute. It'll probably, hopefully be clarified down the road, but I think what it means is that deadly force cannot be used to arrest a suspect who's suspected of a misdemeanor or a minor offense, right? There is an exception even if this, person you're gonna arrest for a misdemeanor might, have a weapon or, have some other, present some other threat, right? Then you have to, use your tactics to confront that. And the degree of force that is used in these situations must be consistent with minimization of injury. That term is also not defined in the statute, but it's something you look at anyways, right? So you've been trained when you get onto scene and you might have to go hands-on with somebody, you look in your toolbox and you see what tool am I able to use based on the facts that I know about what's going on and the situation that I see, right? And so this is a continuation of that reasonable force consideration. The statute also requires that the officer ensures that medical aid is called as soon as possible, which you already know if there's an injury to call for medical aid. And there's also a requirement to notify relatives or next of kin if there's serious bodily injury or death. So these new requirements make it even more important in report writing to write the steps you took when, in any incident. So you want to document whether and how you came to using nonviolent force, or if it was possible, what were the considerations, why did you use the type of force you used in order to minimize injury, right? So it's just super important to include that in reports. As I stated earlier, there is this section that prohibits chokeholds, period. Before, chokeholds were allowed to be used. If an officer was facing deadly force, they could use the chokehold. Now it is not allowed. A chokehold, they did define it as these two incidents, so applying sufficient pressure to a person to make breathing difficult, and they also included a carotid hold as a chokehold. The language in the deadly force statute also changed. Under the new statute, deadly force is justified only when all other means of apprehension are unreasonable given the circumstances, and the arrest is for a felony involving the use or threatened use of deadly force, the suspect poses an immediate threat to the officer or another person, or the force does not and the force that's going to be used does not create a substantial risk of injury to others. And although I just use "and," the interesting thing about how this section was written is these three requirements right here. There is not an "or" or an "and" in the statute. So it could be read as "ors" or "ands." But the important consideration, right, which everyone still does, is based on totality of the circumstances of what the officer knows and what the officer sees. Were all other alternatives unreasonable, and did the person you're confronting and the surrounding situation meet these three requirements? There's also a requirement before using a firearm or other deadly force to warn. So, an officer must identify him or herself as an officer, give a clear verbal warning, and give sufficient time for that person to comply to that warning. Of course, this all depends on the circumstances. So, you're supposed to give that warning unless it would unduly place the officer or another person at risk of death or injury. So when time allows, the warning is required. If not allowed, obviously it wouldn't have to be required. There is a catch-all addition to this law. So an officer, even though what we just went over, even though the wording, an officer is justified in using deadly force if the officer has an objectively reasonable belief that a lesser degree of force is inadequate, and the officer has objective, reasonable grounds to believe and does believe that he or she or another person is in imminent danger of being killed or being seriously injured. So, even in instances where deadly force might not be allowed under that previous language that we looked at, if the officer has these objective reasonable beliefs that any reasonable officer would agree that deadly force would be required in this situation, then the force is justified. The interesting thing about this is that it also includes the objective reasonable belief, but it also includes a subjective belief. So the officer not only has to, be be thinking the same as a reasonable officer would at the scene, they themselves actually have to believe that they're in danger. So this is another time where it's super important to include in written reports what you did. Why was a lesser degree of force inadequate in this situation? What were the steps that you took before using the deadly force, if any? And why did you believe that yourself or others were in imminent danger? And this reporting is important because it's going to help you down the line if there's some sort of criminal prosecution, but also if there's some sort of civil action that comes out of this, these types of cases. It has your contemporaneous report of what you were thinking that 2 years down the road we can look at and say, okay, now we understand what happened. Under the new law, there is now an official duty to intervene. And before I talk about this, I want to just point out that Broomfield policies already include this requirement. It's called duty to intercede right now in policy. And case law, federal civil rights law, also has this requirement of a duty to intervene. And the case law elements are that officers have a duty to intervene when in a position to observe unlawful force being used, or have knowledge of that unlawful force being used, and have a realistic opportunity to intervene. So, and it's also important to remember there's a duty to report as well, and that already existed. So what's been added to this new law? An officer, and that includes both patrol officers and detention officers, are required to prevent or stop unlawful use of physical force in making an arrest, when there's a detention, taking a suspect into custody, during the booking process, and during crowd control or during protest or riot control. Under this new statute, there is an official duty to submit a written report to a supervisor, which again is something that Broomfield officers are already required to do. Under the statute, there's a requirement to have this written report to supervisors within 10 days of the intervention taking place. There is a protection within this new law that if an officer does report an intervention, that the agency is prohibited from disciplining or retaliating against the officer for making that report. The statute also added consequences to what can happen for officers who do fail to intervene. One of those consequences is a potential Class 1 misdemeanor that can be brought against the officer. A second consequence is the imposition of discipline. So if there's a finding that an officer did fail to intervene in a certain situation, discipline would be looked at, and that's if the result of that failure to intervene resulted in serious bodily injury or death. And again, although it says imposition of discipline, officers, just as any Broomfield employees are, they have a right to the personal merit system, and that will be followed. There's also the potential for post-decertification if there's a finding of failure to intervene during an incident that resulted in serious bodily injury or death. Again, unless exonerated by a court, which is what we talked about earlier. I did want to note that regarding the sections that were under the criminal code, so that included the use of force in jails, the use of force by officers, and the duty to intervene, the DAs will be coming out with interpretations of what those mean. And I know they do a yearly training for officers and lawyers. And so I know they're working on that and getting an interpretation out that we can all look at. So this new act does include certain situations where the post board is required to revoke certification of officers. One of those instances is post is required to permanently revoke certification if an officer is convicted, pleads guilty to, or no contest to a crime involving the unlawful use or threatened use of physical force or failure to intervene in the use of unlawful force. That would cause a permanent revocation of an officer's certification. There's also language in this statute that post is required to permanently revoke certification if an officer is found civilly liable for unlawful physical force or failure to intervene in the use of unlawful force. So a finding of civil liability would be when a judge or a jury finds, after a trial, that an officer either used unlawful force or failed to intervene during an unlawful use of force. Again, I don't know how post is going to, what processes they're going to use, but questions have arisen about whether a settlement includes a finding. A settlement would not be a finding. That would be prior to any determination by a court or a jury as to liability of an officer. There is the possibility, if the officer is exonerated in the court, that the post revocation could be overturned. And this information about revoking certification is also going to be included on a database that the Division of Criminal Justice is now required to create. All right, so this was a big part of this new bill. This new bill creates a new civil action. It creates a new way to sue for damages against officers for any alleged violation of Article 2 of the Colorado Constitution. It's important to note that, most of us have, a lot of people probably haven't opened up the Colorado Constitution and see what Article 2 says. Generally, it mirrors federal civil rights, which everyone here is familiar with. So those would include unlawful search and seizures. It would include unlawful arrest, unlawful force. It can include, what you would think as First Amendment claims, freedom of speech and freedom of religion. The legislature has decided in these new civil actions that there's no limits on liability, there's no limits on damages, and attorney's fees are not allowed. So what that means is, so prior to this new civil right action, generally if someone brought a lawsuit in state court, there is something called the Colorado Governmental Immunity Act that would protect employees and officers from suits in state court. And it would also limit the amount of liability that an entity would be liable for. There is a cap of $350,000 for one incident, $990,000 for if more than one person was involved. And there was also no attorney's fees that were allowed under the that act. But now, under this new act, there's the ability to sue an officer in state court for this state action, and these suits would now be not subject to any of those limitations that I just talked about. There's also stated language within this act that an officer is not entitled to qualified immunity defense. So most of you are familiar with the federal qualified immunity defense. And that defense is a defense that generally shields officers from suit as long as their conduct does not violate clearly established law, which a reasonable officer would have known. So in federal cases, what we're able to do is file a motion saying this officer should be dismissed out of this case because they did not violate clearly established law based on all the law that's been established regarding police conduct, right? In these new state actions, we're not able to do that. So we would not, that defense would not be available. The new act also has an indemnification provision. So under the indemnification provision, the city and county is required to indemnify an officer in almost all situations. So what does that mean? That indemnification means the city would be responsible for any settlement or judgment that is awarded in the case. The two exceptions are if an officer, as determined by the city and county, did not act in good faith and reasonable belief that their action was lawful, then potentially the officer would be personally liable for the lesser of $25,000 or 5% of any judgment that happens in that case. The city has started discussions about how we are going to determine that. There has been no decision made. But those are going to be the rare cases, right? Because generally, if officers are, acting pursuant to policy, they're acting in good faith, they're acting based on their training and the laws that they have been trained on, then generally you're going to be acting in good faith and be fully indemnified. The only other time the city and county would not have to indemnify is if there was a criminal conviction for the actions that took place during that incident. These new civil actions have a statute of limitations, so they can be filed up to 2 years after the incident, and that's the same as it is in federal civil rights cases. All right, these next two slides are information for you to be aware of that are also in the new law. The AG now has the ability to bring a civil action for a pattern or practice violations, and that would be, this would be a civil action against the city. If they do an investigation and they see that there's, some pattern or practice of violation within Broomfield, they would be able to file that action against Broomfield. They are also given the power to file criminal actions for certain post requirements that are not being followed and not being followed willfully. Post also has new powers and duties under this statute. Like I've been saying, they are required to come up with rules and procedures regarding the different aspects of this law that we talked about. They're also being required to come up with standards and training, which they do anyways, but they are supposed to do that in response to this bill as well. They're also required to create a database that would contain information about untruthfulness of an officer, if there's repeated failure of training by an officer, decertification, or if an officer was terminated for a cause. And then on top of all the other post decertification consequences that we talked about, they are also able to decertify an officer if that officer fails to complete required training. This part can only be done if the officer is given notice first and has the ability to correct that. All right, this is also information for you to know. This doesn't happen until January 1st of 2023, but beginning on that date, all police departments within the state are going to be required to give information to the Division of Criminal Justice. That information is going to include all use of forces that resulted in serious or death or serious bodily injury. The information that we are required to give to the division is the demographic information of the individual, the names of the officers that were involved in that situation, the type of force used, whether that use of force was investigated by the city, and whether there was a complaint that was submitted by a citizen. Broomfield's also going to be required to report anytime an officer resigns while under investigation. We're required to provide data on contacts, which we will talk about in a second, about what that means. And then we're also required to give the division information about instances where there was unannounced entry into residence, whether it was a result of a warrant or not. And again, that information about unannounced entries would include demographic information of the subject, and whether a weapon was unholstered or discharged. What the division will do with this information is create an annual report and also a publicly available database. So on their website, they are required to put all this information onto a database that'll be searchable by department. So anyone in the public can go onto that database, search, Broomfield, the Broomfield Police Department, and see what has occurred in Broomfield during that time. All right, the next big section that was included in this law was changes to the profiling statute. So the new addition to that statute is under 2431-309 3.5. And that section now reads that a peace officer shall have a legal basis for making a contact, whether consensual or non-consensual, for the purpose of enforcing the law or investigating possible violations of the law. So we're going to break down what this might mean, because a lot of this is not defined. All right, so we'll start off with what contact means. Contact is defined within this new law. A contact is defined as an interaction with an individual, whether or not that person is in a motor vehicle, initiated by a peace officer, whether consensual or not, for the purpose of enforcing the law or investigating a possible violation of the law. So what does that mean? A contact, then, can be any time an officer has in-person contact with a potential suspect or any other individual that's initiated by that officer for the purpose of enforcing or investigating the law. The statute does say that contacts do not include routine interactions with the public at the point of entry or exit. This was included, I think, because while this law was being made, there was a lot of concern about, times that citizens go into the police department to talk with an officer, or, casual contacts. I think those casual contacts were excluded, but this is now the definition within the law about what a contact is. So the next question is, what's a legal basis? This is not defined. So generally for officers, you have a legal basis to make contact with a person if there's consent, right? If there's reasonable suspicion or probable cause. This law doesn't change the ability for consensual stops, but it was written, I believe, to stop the instances where an officer might stop somebody, right, purely based on profiling. So purely based on someone's race or the color of their skin, right? And so what's important to remember is, consensual stops, that's still law. It's still, allowed under the Fourth Amendment, right? But another consideration is looking at an officer's state of mind. So if an officer's state of mind turns to, I'm going to investigate something, if it's an investigatory contact, then arguably what this law says is that you have to have reasonable suspicion or probable cause to make that contact. Now, this is part of the law that definitely is going to have to be clarified either by guidance or, when case law comes down, because this can come up in criminal prosecutions, right? That there wasn't a legal basis to stop me, so, a motion to dismiss, right? It could also come up in the civil context, saying it was an unlawful seizure because you didn't have legal basis to contact me. So this is something that is definitely going to be requiring clarification down the road. So there's also a new data collection requirement. So after making these contacts, an officer is now required to report certain things regarding the contact. And I know that a Google form has already been distributed to officers that contains each separate section of what the requirement is. And there may be changes to that Google form. It might change the form, we might not use Google down the road. But this is the information that's required to be reported. So number one, the perceived demographic information of the person being contacted. And that demographic information includes race, ethnicity, sex, or appropriate age. And they say perceived demographic because obviously sometimes you're not going to know, right? And but this information, you have to use the best information you can. If it's unknown, then I think that's, you can say unknown. The next information is whether it's a traffic stop, the time, date, location of the contact, the duration of the contact, the reason for the contact, the suspected crime, and the result of the contact. So was there no action taken? Was there a citation issued? Was there an arrest or was property taken? Was there a warning provided? If there was an arrest, what was the charge? And if it was a traffic stop, the information is limited to the information related to the driver, not the passengers. The information in this paragraph continues about what actions were taken by the officer during the contact. So was there a request by the officer to search the person or the vehicle and noting whether or not that consent was given? Was that person searched? Was property taken? Was their property searched? Was the car searched? And then it also goes on to require documentation as to whether a weapon was unholstered. Weapon is not defined in the statute, so weapon could mean anything from a taser, a firearm, a baton. It could be any of those. And then ultimately whether the officer discharged a firearm during that contact. And again, right now I think the Google form is really helpful because you don't have to remember all this. You just have to go down and answer those forms. But this is required anytime there's a contact, so an in-person contact with a person for the purpose of making, for investigating the law or for some other lawful purpose. This information will go back to that report that we talked about that the Division of Justice is required to create. So all this information is going to the Division of Criminal Justice, and beginning in January of 2023, there's going to be that database that's going to be created that will contain all this information. This is something I think that also is going to be clarified because the Division of Criminal Justice is now questioning how all this information from all these different organizations all over Colorado is going to be given to them, and then they're going to be responsible for, creating this database. So I wouldn't be surprised if they give us some guidance as to use this form, answer these questions, so that there can be a uniform response to how this goes down. And the information, obviously, that we give to the division could also be looked at by the AG to see if there's a pattern of practice, for example, of racial profiling. So I think, obviously, this is a lot of information. This is a new law. Like I said, this isn't going to be the first time we're going to talk about this. There's going to be changes. There's going to be clarifications that are going to be coming down, and we can talk about it again. You're going to have training. This training is going to be included in your use of force training. And we'll just continue to keep you updated on what we learn.